Dark pleas, they sound menacing, and they can be if you're a prisoner who's been wrongfully convicted. Go home to your family, but forever be labeled a felon. It's an excruciating choice. Lead investigator Brian Duggar digs into these post-conviction deals that have one Ohio Supreme Court justice calling for change.
The legal equivalent of placing a gun to someone's head.
They're trying to cling to some version of a guilty judgment.
On March 28th, Wayne Brady and Carl Willis stood up in court, giving up their hopes for exoneration and taking a deal from prosecutors so they could go home after 23 years of professing their innocence from behind prison bars.
I'm an innocent man, but I do want to go home.
Ohio Supreme Court Justice Michael Donnelly has a name for these post-conviction deals.
That's the dark plea, and it's a level of coercion that I would describe as the legal equivalent of placing a gun to someone's head and forcing them to confess to something that they don't want to do.
The targets are particularly vulnerable, inmates often serving life sentences, but inmates with legitimate claims of innocence.
Their choice is go home free or gamble on winning your case ultimately, even though you're innocent, in a system that's already failed you once. Remember, all of these people were convicted in the first place, and for those who are in fact innocent, their innocence didn't matter.
University of Wisconsin law professor Keith Finley has compiled data on these post-conviction deals. In cases where inmates have strong claims of innocence, like Brady and Willis, prosecutors offer deals 23% of the time.
That's an extraordinarily high rate, because that means those are the cases where they're agreeing to vacate the conviction, or where the conviction has already been vacated based on new evidence of innocence, and yet they're trying to cling to some version of a guilty judgment.
There have been 4 deals in Lucas County in the past year that would qualify as dark pleas under Justice Donnelly's definition. Hector Alvarado, released in July after being convicted of a woman's 2013 killing. Brady and Willis, released in March. They're in prison for a 1998 killing. And Stoney Thompson, released in November after being granted a new trial for 3 2006 murders. All 4 men professed their innocence and had strong cases to prove it. All 4 gave up their right to fight for exoneration, and they gave up an opportunity to receive compensation from the state.
My client was shot at.
Thompson's lawyer, Michael Stahl, says it was an understandable choice for his client.
We talked to him about it, and he wanted to do it. What's the right answer to that? And I don't know what I would do in those shoes. You know, it's like you have a chance to go have a life again.
In Brady and Willis's case, prosecutor Julia Bates told the court it was time to end the legal fighting.
And I think sometimes, Judge, the case needs closure. I think sometimes the case needs to be over.
But Justice Donnelly says it's important to question why a prosecutor offers a deal at any point in the post-conviction process, a conviction they are still defending.
And the conclusion that I've come to is a prosecutor that had a good faith belief in the integrity of the conviction would not offer a dark plea until he or she knew that they had to face a new trial. And the only reason they would offer it before they learn that is that they feel they are going to lose.
Finley says the prosecutor may believe in the conviction, but there are other reasons they give up the fight.
It runs the gamut from that to simply not wanting to be responsible for freeing someone in the off chance that something bad would happen later, to fear of civil liability for the county or the jurisdiction for a wrongful conviction, to downright maliciousness.
Donnelly, Finley, and Stahl all agree that the time inmates wait on getting a hearing for their appeal increases that pressure to accept a dark plea. Now, the state is currently considering a rule that would require a hearing on the claim, a prompt hearing.
This is about transparency. So if a prosecutor believes that the claim for a new trial has no merit and the claim of new evidence is not credible, then they should embrace the idea of a hearing so they can demonstrate that and the judge can rule accordingly.
He says it would be a big step in a state where the post-conviction process is stacked against those who claim innocence.
The stars really have to align for someone who claims that they are innocent. You have to have a good lawyer, a judge willing to have a hearing that's really not required under the law. Sometimes you need celebrity involvement, and it shouldn't have to be that hard. You know, we should have a system where the primary goal is the truth.
There have now been 3,325 nationwide exonerations since 1989, nearly 30,000 years lost. All three men I interviewed say that a conviction integrity unit in Lucas County would be a way to ensure more confidence in our local judicial system and make these dark pleas less likely. Now, I've asked Prosecutor Julia Bates multiple times to discuss the issue. She has not responded, and she also did not respond to a request for comment for this story. Reporting in studio is Brian Duggar for WTUL 11.